Hi everyone, this is Khushboo Chokshi and today I'll be doing a quick revision video of the LLP Act which is applicable for your CA Foundation examination and which comes for a total of 5 marks in your papers, and that too it's an optional question that has been asked. But I always recommend that even though it's an optional thing and even though it's for 5 marks, you should study it because it's a very small act. It's a very easy act and it's very easy to score that 5 marks. Even if you're planning not to attempt the LLP Act, even then it makes sense to study the LLP Act and go for the examination, so that if there is any other question which you are unable to answer because it's a practical case study type of question and you're not sure as to what the answer there would be, you can always come back and answer the LLP Act. Also, the second advantage is that the LLP Act comes as question 2B, and the question 2A is a theory type of question from the Indian Contract Act. So Indian Contract Act is something that you are going to study and not leave it for option. Then the question is a theory question, so there are less chances of you going wrong because it's not a practical case study type of a question. So you have 2A as a Indian Contract Act a theory question and 2B as a LLP Act, again a theory question, because there's not much scope in the LLP Act to ask a practical case study type of question. So it's very easy to attempt question 2, and if you've done your LLP Act, which I assure you, if you've studied well, if you go through this video, and I'm attaching the summary notes along with the video, so if you go through this video, even on the last day you will be able to attempt those 5 marks very easily. And the questions again which are asked are very repetitive type of questions. I've given the questions here so that you can see for yourself what are the essential elements of LLP form of organization. Again, same question asked in November 18, what are the essential elements? It's an alternative corporate business, so basically giving the features of a LLP form of organization and what conditions under which LLP will be liable and not liable for the act. So if you see, the questions which are asked are again fairly simple, which you would be able to answer in your examination. So do not leave it for options. See the video on the last day, see the summary notes which I am attaching, and those summary notes covers all the points, so you just see them on the last day for half an hour, study it, and you can go and give your paper and you will be able to attempt those 5 marks of your LLP Act question. Okay, now coming to what is LLP form of organization. LLP form of organization is nothing but a mixture of an Indian Partnership Act and a company form of organization. Indian Partnership Act, is basically where two people come together with a view to earn profit, to do a business with a view to earn profit, and the liability of the partners is unlimited. In the company form of organization, your liability is limited, but the disadvantage is that you have to do a lot of compliances under the Companies Act. So in 2009, the LLP form of organization was introduced so that you have the benefits of both the Indian Partnership Act and the Companies Act. That being that you have the flexibility of having your LLP like a partnership form of organization, and the advantage from the Companies Act is that you get limited liability. Now in Companies Act you have a lot of compliances to be done with the Registrar of Companies. Here the compliances are very restricted, and they are very minimal compliances that a LLP will have to do with the Registrar of LLPs. So it's basically a mixture of Partnership Form and Companies Act, both the acts which you are going to study, because Companies Act, even though you get for like very less marks, you have to study because otherwise you will not know what to study in Inter, right? Because it's the foundation, so you have to study both those acts. And LLP Act is just a mixture of the 2 acts, so you have to study, you can't miss those 5 marks, correct? So what are the differences between the LLP form of organization and the partnership form of organization? LLP form of organization, obviously you have to get yourself registered under the LLP Act, and partnership you have the flexibility of registering or not registering. Here you have to add your name's LLP behind your LLP name. Partnership firm doesn't have any such requirements. You have common seal, here you don't have common seal. The most important thing is that the mutual agency concept in the partnership firm, what happens is that the partner is liable not only to the firm, but he's also an agent of the other partners, whereas in the LLP Act he is an agent of the LLP only and he's not liable for the act of the other partners. In partnership form of organization, the liability of the partners is unlimited. limited. So if there is any liability which has been put on the firm, then the liability can also be recovered from the personal assets of the partners. But in the LLP form of organization, similar to a company form of organization, the liability of the partners is limited. So the personal assets cannot be used for paying off the liability of the LLP. Now comparing it with the company form of organization, here in the company form of organization you have a lot of compliances to do, which you don't have to do in the LLP form of organization. In LLP you need 2 people to start the LLP. In company form of organization, if you are a private company, you will need 2 people. If you are a public company, you will need 7 people to start. Here you have to add your words private limited or public limited based on what kind of company you are. Here you have to add the words LLP. And the liability in both the LLP form of organization and the company form of organization is limited. But in company form of organization, at the time of incorporation, you have to file the memorandum of association, articles of association, and you're governed by the Companies Act as well. Here you're governed by the LLP Act. You're not governed by the Partnership Act. You're governed by the LLP Act, and you just have to get an LLP agreement in place, and you will be governed by that LLP agreement provided it is in sync with the LLP Act. So that is the differences. It has not been asked in your examination yet, but it is a question which can be asked in your examination because it's a theory type of question and it's perfect for a 5-mark question. So I have put it in a tabular format, and I would just request you to just go through the differences between the LLP and the company. LLP and company, LLP and partnership firm. Now, again, what is the meaning and concept? We have already studied that it's an alternative business vehicle which can be used, which has limited liability. So, all of those things are again repetitive. Definitions, I am not going to go through all the definitions. I have put them here. You can go through them. But the most important definition here is the minimum number of partners which is required under Section 6. You need 2 partners at least, and if there is only 1 partner and that 1 partner continues to carry on the business of the firm for a period of 6 months without getting another partner, then that partner will personally liable for the business of the LLP. And designated partners are like, you know, the CEO of the company who will be doing the day-to-day running of the partnership firm. Just a partnership firm, you have you know, all the partners are equally responsible for all the compliances that a partnership firm has to make. But in the LLP form of organization, the designated partners are the people who are you know, responsible for the day-to-day compliances. So if something goes wrong, you will see as we go further in the act that the designated partners are penalized and not the partners of the firm. So designated partners are important. You need to have 2 partners. One of them has to be an individual, and these designated partners has to be resident in India. That is, they have to stay in India for a period of at least 182 days. And if you have both the partners as a company form of organization, then you need to have some you know, authorized representative of that company form of organization to work as a designated partner. Now, so these are the 2 most important definitions. The other definitions you can just go through in the notes. What are the important characteristics of an LLP form of organization? Now we'll see how it's a merger of the partnership form of organization and the company form of organization. It's a body corporate, so it has its own individual you know, individual legal person, like how you have a company. So it's a body corporate. It has perpetual succession. In a partnership firm, if the partner dies, if there are 2 partners, one partner dies, then the other partner cannot carry on business because you need at least 2 people, and then the LLP has to be dissolved. But because this is a body corporate and a body corporate cannot die, there is perpetual succession, again like a company form of organization. It's a separate legal entity different from the person. So why is that important? If there is some non-compliances in the LLP Act, the LLP will be penalized and the partners will be penalized. There's always a distinction between the 2, like how you have in a company form of organization. Mutual agency, as we discussed, is about that the partner is an agent of the LLP and he's not the agent of the other partners. This is something which we have studied in the Partnership Act, where the mutual agency in Partnership Act is that a partner is an agent of the firm and the agent of the other partners. That is not the case in LLP. Then there is a LLP agreement. Similar to how you have it in the Partnership Act, you need to have a LLP agreement in place between the partners, and the relationship between the partners will be governed by the LLP agreement. If you do not have the LLP agreement, there is a first schedule to the LLP Act which gives out the LLP agreement, which you can refer to if you don't have an LLP agreement between the partners. It's an artificial legal person, that is, it cannot die, but it is a separate a separate legal person, and it is recognized separately. So the partners will file their own return, but the LLP will file its own return. Like how you have in proprietorship, if I filed my return, I'll also will have to include my income from the from my sole proprietorship, but that would not be the case in a LLP. LLP will file its own returns, it will have its own penalties, it will have its own rights and liabilities, correct? So it's an artificial legal person, like you have a company. It has a common seal. You can have a common seal if you want to. Common seal is not required, similar to how you have in the Companies Act. It's not mandatory, and if there's no common seal, the designated partners can sign the documents, and then that will suffice. Limited liability of the partners. The most important feature of the Limited Liability Partnership Act is basically you have the partners, the liability of the partners is limited. That is, that the personal assets of the partners cannot be used for paying off a liability of the LLP. Then the management of the business will be by the designated partners, as we have studied in the definition, that the designated partners are the people who are like active partner in the Partnership Act, or the CEO of a company, who will be managing the day-to-day affairs of the company, and they will also be responsible for fulfilling all the compliances which the LLP has to do. Then the minimum and maximum number of members, there are no limit on the maximum number of members, but minimum you need 2, because it's a partnership. So you can't have your partnership with yourself, correct? So you need some partner to do it, and that partner you come together for the purpose of doing a business with a view to earning profit. So you cannot have it for a charitable purpose. So it's a business for profits only. Investigation, compromise or arrangement, these are all secondary clauses. Conversion into LLP, again you can have a partnership firm which you can get converted into LLP. You can have a company form of organization which you can get converted into LLP. So if you have already existing business in any other form of organization, you can convert it into LLP. Then the documents of the company, the LLP, which are the statement of accounts and solvency, the annual return, or if you're changing your LLP address, or if you're changing your LLP partners, or if you're changing your LLP agreement, all of these documents you have to file with the registrar of LLP. Like how you have the registrar of companies, like any changes you do in the company has to be intimated to the registrar of companies. Similarly, in LLP, any changes you do to the LLP has to be intimated to the registrar of LLPs. All these documents have to be e-filed, and there's a portal where you have to just upload the documents, and then it will be approved or rejected. And then there are foreign LLPs. What I meant by foreign LLPs is basically that those are LLPs which are registered outside India, but they have some business in India or a place of business in India. Those are called foreign LLPs, and if they are in India, obviously, then if they are carrying on business in India, then they'll be governed by the LLP Act in India. Now, what are the advantages of LLP form of organization? Now, again, you'll see all of these things are quite repetitive. So, it is operates on the basis of an agreement, which you've studied in the features, that it has an LLP agreement and does not have memorandum, articles, all those big documents. It has a LLP agreement, and it has a flexibility of partnership, I said in the beginning. So, this is the flexibility, that you have an agreement between the partners. You can have the agreement the way you want to. So, that is the flexibility that is given here. It provides flexibility. See, so I said it provides you flexibility because there's a LLP agreement. Easy to form because you don't have to do a lot of compliances. Partners enjoy limited liability, again a feature which we just discussed. It has a flexible capital structure, so there is no requirement that you have to have a minimum capital of this much amount. The partners can contribute as much as they want to, and hence they have a flexible capital structure, and it's easy to dissolve. So if you have to wind up a LLP and if you have to wind up a company, winding up of a LLP is much more easier as compared to winding up of a company. Now coming to incorporation of LLP, which is covered under section 11 of the LLP Act. So, incorporation of the LLP. If I have to incorporate the LLP, there are certain documents which I need to file with the registrar of LLP in the form as may be prescribed. The people who are coming together to carry on the business of the LLP will come together as subscribers to the LLP agreement, and they will subscribe to the LLP agreement. They'll form the LLP agreement, they'll file all the necessary documents in the prescribed format with the registrar of LLP. All these documents will be attested by a third party, which will be like a CA or a CS or advocate. All of those options are given in the forms, and these people will certify that the details which are being uploaded are true or correct. So if I upload something which is wrong, and if a CA is certifying that, I will be held responsible obviously for furnishing incorrect information, but the CA will also be held responsible. So there's a third person who is going to always sign those documents and give a approval saying that okay, these documents which are being submitted are true and correct to the best of his knowledge. So this is what you have to give. Now the incorporation document will give the name of the LLP. What is the proposed name that you're planning to give? So you first do the name approval. They give you like 6 boxes to fill, saying that okay, these are the 6 different names which I propose to incorporate my LLP with. So they will approve one of the names out of the 6 names you've given, and you have to say why the name, for what business you're carrying on. So you have to give the proposed business of the LLP, saying that what business I am planning to carry on, and hence how my name and my business is related. Once you submit that, then the name approval will come. Once the name approval comes, then you give the LLP agreement and you say okay, these are the LLP agreements, these are the people who are supposed to be the partners of the organization, this is the name and address of the person who are going to be the partners in the organization. So you give the address of the registered office as to where you're planning to carry on the business of the LLP, name and address of each person who are going to be the partners of the LLP, and name and address of each person who is going to be the designated. So you give all the details about the LLP which you are going to be incorporated, and you give it to the registrar of LLPs. The registrar of LLPs will look at the document, will verify all those documents, and once it is once all the documents are filed and the documents are sufficient, then the registrar of LLP will give you a certificate of incorporation. The certificate of incorporation is basically like a birth certificate you give to an individual. From that date, the LLP will come into existence, and all the provisions of the LLP Act will be applicable to that LLP from the date of the certificate of incorporation of LLP, similar to how you have in the Companies Act. Okay, so within a period of 14 days it will register the incorporation documents. Once you file all these documents, within 14 days it will say okay, you are registered or you're not registered, or these are the issues, and you'll have to resubmit the documents. So within 14 days the registrar will give its approval and register the LLP. Now what are the registered office of LLP and any changes therein? As I have mentioned earlier, if you are filing any documents with the registrar, and if there are any changes to the documents that you're filing with the registrar of LLPs, that has to be intimated. Similarly, if you have a LLP office, and if you're changing your LLP office from say Mumbai to in Andheri in Mumbai to Bandra in Mumbai, then you'll have to file the necessary documents with the registrar of LLPs. Again, what are the effects of being registration of LLP? You can now be sued, and you can sue someone else basically in the name of LLP. You can acquire, own, hold property, you can transfer property in the name of the LLP, you can have a common seal if you decide to have one, and you can do such other acts as a body corporate can do. Then the name of the words LLP will have the words LLP at the end of it. When you make an application, you have to ensure that you don't give an application for a name that has already been registered or which is registered as a trademark. If you do that and if it has been approved, then the central government at a future date may give you a notice saying that you will have to change your name, and within 3 months you will have to change your name and give a new name to your LLP. If you don't do that, there are penal consequences. Steps to incorporate LLP. Again, this is something which I just discussed, that you first have to do your name reservation, then you have to incorporate the LLP, give the details of the partners and the designated partners of the LLP, the name and address, and then you file the LLP agreement saying this is the agreement which is agreed between the parties, and that agreement you file with the LLP registrar of LLPs. Partners in the relationship. Again, the partners of the LLP are liable only to the LLP, and they are not liable for the acts done by the other partners. So it is in that way different from a partnership form of organization. Now, the relationship between the partners, as I mentioned, is governed by the LLP agreement. If there are any changes to the LLP agreement which you have filed with the registrar of LLPs, then you will have to intimate the registrar of LLP saying that these are the changes, and that changes has to be will be applicable to the partners. And in absence of agreement, the first schedule will be applicable, first schedule of the LLP Act. Now, cessation of partnership. If I don't want to be a partner, how can I go out of the partnership agreement? I decide I don't want to be a partner, or on the death of the partner, or due to insolvency of the partner. These are reasons why I would want to go out of the partnership firm. Now, if I decide I don't want to be a partner of the partnership firm, I'll have to give a notice to the LLP saying that I do not wish to continue as a partner of the partnership firm, and LLP will have to give a notice to the registrar saying that this person is no longer a partner of the partnership firm. The day I give the notice to the LLP, from that date onwards, if there are any acts done by the LLP, I will not be held liable for it. Till that date, I will be held liable. Similar to how you have to give a public notice in the partnership form of organization. And once I decide that I want to move out of the LLP partnership, then I will be getting an amount equal to the capital contribution which I have already given, and I will also have a right to the share in the accumulated profits of the LLP. So those are the things which will be given to me as I quit the organization. Now, registrations of change in partnership. I said you have to inform the LLP, and the LLP will inform the partner. So it has to be informed, the partner has to inform to the LLP within 15 days, LLP has to inform to the registrar within 30 days. Okay. Then if you don't do that, again there are penal consequences. Both LLP and the partner will be held liable, designated partners, if the compliances are not done. Then partner acts as an agent of the LLP but not of the other partners. This I said is very, very important, that it is hence different from the partnership form of organization, where in the partnership form of organization the partner is also an agent of the other partner. So that is different here. The extent of liabilities is whatever he is done which is within his authority. The LLP will be liable only for the acts done by the partners which are wrongful and within his authority, but the liability of the partner will be limited, it will not be unlimited, which means that the personal assets of the partner will not be recovered. But if the LLP or the partner does some fraudulent activity to defraud the creditors, in that case the liability of the LLP and the partner will become unlimited. Partner by holding out is where I am not a partner of the firm, but I show it to the public that I am a partner of the firm, and based on my showing that yes I am a partner of the firm, people give money to the LLP, and hence if that happens where I show that I am a partner of the LLP of the LLP, and someone gives money or gives credit to the LLP based on believe that I am a partner of the LLP, then in that case I will be liable to that person to that extent, even though I am not a partner of the LLP, but because I have acted as a partner by holding out. and unlimited liability in case of fraud. I've told you whistleblowing is where I have been held liable for something where the LLP has done something wrong, or I know that the partners have done something fraudulent. Now I go and tell the court that I will help you in giving you details as to what they have done wrong, and I'll come up and I'll honestly answer your questions. So that is whistleblowing. So the court will say, if you assist me in giving me information as to how the fraudulent activity has been carried out, then we'll reduce your liability, or we'll not hold you liable for any act you've done under the act. Then coming to the financial disclosures, there are two most important forms which have to be filed by the LLP. One is the statement of accounts and solvency, and one is the annual return. Statement of accounts and solvency has to be filed within 6 months from the end of the financial year, and annual return has to be filed within 60 days from the end of the financial year. 60 days from end matlab 31st May tak karna hai and 30th September. These are the two forms which they have to file, Form 8 and Form 11. If you do not file the forms, then the liability under both is similar, where LLP and the designated partners both will be held liable. Conversion of a partnership firm into LLP, a private company into LLP, all of this is possible. And once you have made an application for conversion of your form of organization into an LLP form of organization, then obviously from the date of conversion, the LLP provisions will apply to you, and the provisions of that particular act will not apply to you, provided you have given a notice within 14 days of such conversion to that respective, the registrar of firms or the registrar of companies, saying that I have converted my organization from company to LLP, or from partnership firm to LLP. So that is the effect of registration. And winding up and dissolution, you can wind up the company. This is important, probably this can again be asked for a 5-mark question. If the LLP decides that it wants to wind up its organization because they're not doing any business, or for 6 months they do not get a partner and the person is alone carrying out the business, so there's no partner, there's no partnership, and hence you can ask for dissolution. If you've not filed the necessary statements with the registrar for a period of 5 consecutive financial years, then again you can apply for winding up. Or if the tribunal feels that it's just an equitable to wind up this LLP, then you can apply for winding up. If you are unable to pay the debts, or if you have acted against the interest of sovereignty and integrity, then you can apply for winding up. So these are the 5-6 scenarios where you can apply for winding up and dissolution, and that is covered under section 63. So so this basically ends the LLP Act. It's a very, very simple act. Go through the video. I am attaching the notes. Go through the notes and revise it. It's simple. It will come for 5 marks and you will be able to answer that. I hope you've understood it. I hope the video helps you. If you have any doubts, you can drop a comment, or my number is given here and you can just write to me and I'll get back to you. Have a nice day. Thank you so much.